The Nuremberg trial was a historical event. As a matter of fact, it put international criminal justice on the agenda of the United Nations that had been established in 1945. However, as we all know, it would take a long time for the heritage of Nuremberg bore fruit within the organization. Today, I think that the Nuremberg heritage is best summarized by referring to the principles of international law recognized in the Charter of the Nuremberg Tribunal and in the judgment of the Tribunal, the so-called Nuremberg Principles. They were elaborated by the United Nations International Law Commission and presented to the General Assembly in 1949 and 1950. The hallmark of the 7 principles is that any person who commits an act which constitutes a crime under international law, including persons acting as head of state or responsible government official, is responsible therefore and liable to punishment. The crimes defined in the principles are crimes against peace, war crimes, and crimes against humanity. As we all know, it took a long time before the work in this field within the United Nations bore fruit. However, these principles are now translated into the rules of the International Criminal Court. I'm not going to delve deeper into the legacy of Nuremberg now, and we've heard, for example, this morning, so much about it. What I am going to do is to refer to the excellent keynote address that Professor Leila Sadat delivered on the 20th of November last year at a conference here in Nuremberg commemorating the 70th anniversary of the Nuremberg trial. It's published by Washington University in St. Louis as a research paper entitled The Nuremberg Trial, 70 Years Later. I must say that I agree very much with the analysis that Professor Sadat makes in this address, and in particular when she concludes by restating the obvious, quote, "The record of compliance with the Nuremberg principle is mixed. At the same time, the Nuremberg legacy itself is extraordinary and its importance is hard to overstate." Two of the situations she mentions I remember with particular concern, since they occurred during my tenure as the UN Legal Counsel between 1994 and 2004, namely the attack on the World Trade Center in 2001, which I saw from my windows in the UN building, and commonly referred to as 9/11, and also the attack by the United Kingdom and the United States of America and their allies on Iraq in March 2003, the low watermark. I never forget when the 50th ambassadors asked to see Kofi Annan, not asking him to come down to their conference room, to come up to his meeting room, asking his advice. We were 4 undersecretaries present then. I was wondering. With respect to 9/11, I'm afraid that this was a very dangerous turning point, which could be seen as a first step in the development that we have seen over the past years, namely, the Western democracies have backtracked with respect to protection of human rights. Guantanamo is still not closed, and many countries, including my own, have participated in extraordinary renditions and incarcerations under conditions which are totally incompatible with applicable international human rights standards. I therefore completely agree with Professor Sadat when she says that, particularly since the attack of September 11, 2001, the Nuremberg principles have been undermined by the policies of the very nations that gave them birth, including my own country. With respect to the attack on Iraq by the United States and the United Kingdom in March 2003, this was a flagrant violation of the UN Charter. Since the attack was not in self-defense, a resolution by the Security Council was a necessary precondition for the use of armed force in this situation. The United Kingdom clearly understood this, but the efforts by the UK permanent representative to the UN, my friend Ambassador Jeremy Reestock, to gain support for such a resolution were in vain. What happened in the United Nations, what happened on the United Kingdom side at the time has now been clarified by the Chilcot Commission, And might I add that I was extremely glad to note that Sir Michael Wood had exactly the same position as I had in the UN. A new resolution was necessary, but it wasn't forthcoming. However, the attack was not only a violation of the UN Charter, it was also a clear violation of the Nuremberg Principle 6, which defines crimes against peace as, number 1, planning, preparation, initiation or waging a war of aggression, or a war in violence of international treaties, agreements or assurances. And number 2, participation in a common plan or conspiracy for the accomplishment of any of the acts mentioned under number 1. This kind of behavior has also been resorted to by another permanent member of the UN Security Council. I'm referring to the attacks by Russia on Georgia in 2008 and on Ukraine in 2014, including the annexation of Crimea. In my view, the issue of Crimea, I can fully understand the concern in Moscow if Crimea would end up as a NATO territory or European Union territory. But that question could have been solved through negotiations and agreements if sufficient statesmanship had been demonstrated in Moscow, in Kiev, and in the West. Under all circumstances, the fact that the permanent members of the Security Council behave in this manner constitutes a serious threat to international peace and security. And at that, generated by members of an organ entrusted with the primary responsibility for the maintenance of international peace and security. Let us now focus on my second main part, the present geopolitical situation. And here I will address 3 aspects: the world population, the global economy, and refugees, in particular refugees generated by climate change. The world population. We were some 2 billion people when the United Nations was established in 1945. Today we are 7.4 billion, and according to the UN, the population division will be some 9.6 billion at mid-century. The population division has also looked further into the future, about 300 years, and come to the conclusion that the world population will stabilize somewhere around 9 billion people. But under all circumstances, this is a major growth of the world population, and it is inevitable that this will have very great effects on the human habitat. The world economy. As far as the world economy is concerned, some 10 years ago, my attention was drawn to an article published by Keystone India containing a presentation of the distribution of the world gross domestic product, the GDP, in 2004, with estimated figures for 2050. What were the figures in 2004? The European Union had 34% of the world GDP. The United States of America, 28%. China, 4%. India, 2%. China, India has about 1.4 billion inhabitants. Japan had 12%, and others 20%. What did they estimate for 2050? Europe would plummet from 34 to 15, 1.5. US would retract a bit from 28 to 26. China would soar from 4 to 28, bypassing the US. India up from 2 to 17, and Japan down from 12 to 4, and the others from 20 to 10. Interestingly, the others would even have less participation in the GDP than these first 4 countries mentioned and the European Union. Of course, these were predictions, the estimates for 2050 that must be understood precisely as estimates. But when I last looked at the GDP figures published by the World Bank, I realized that China has already bypassed the US in GDP terms. The GDP figures for 2015, based on purchasing power parity, the PPP model, they are $17,946 billion for the United States and $19,524 billion for China. I just wanted to mention this as an indication of the enormous geopolitical shift that we will see over the next few years, and which will also have effects on the legal situation in the world. Another question that must be kept in mind in this context is my third aspect, refugees. Here in particular, refugees generated by climate change and its effect on the living conditions of humankind. Last week I attended the International Bar Association's annual meeting in Washington, and I had the privilege of moderating a panel discussing the question, who is a refugee? By coincidence, this happened on the 20th September, the day after the high-level annual meeting in the UN addressing this issue. On the 19th September, the UN General Assembly had adopted the New York Declaration for Refugees and Migrants. At the IBA conference, the highly qualified panelists discussed the refugee topic from various points of departure. References were made to the declaration just adopted by the UN General Assembly and the present situation in Europe and Asia. The number of forcibly displaced persons in the world today is some 65 million people, including over 21 million refugees, 3 million asylum seekers, and over 40 million internally displaced persons. The conclusion of this panel was that the 1951 Convention of the UN related to the status of refugees is still relevant in today's world. However, in the discussion, there was special focus not so much on the articles of the Convention as on one of the provisions in the preamble, quote, considering that the grant of asylum may place unduly heavy burdens on certain countries, and that a satisfactory solution of a problem of which the United Nations has recognized the international scope and nature cannot therefore be achieved without international cooperation, unquote. The conclusion in our panel was that such cooperation is absolutely necessary, and that there is a serious risk that this is not forthcoming in spite of the declaration just adopted by the General Assembly. For my part, I can definitely see consequences for international criminal law here. With respect to the 1951 Convention, of course, we have to realize the context. This was an instrument that was born after the Second World War. However, in the discussion, I pointed to another phenomenon that might generate refugees, namely climate change. The main factors here are desertification and sea level rise, since both will cause situations where land becomes inhabitable, with the result that people who now live in these areas will be forced to flee. After I left the United Nations in 2004, I had reason to focus specifically on the polar regions and the effects that climate change in these regions will have on the rest of the globe. I've come to realize that not many people are aware of the size of these regions and the differences between the two. In Antarctica, 53 states have a well-functioning cooperation within the framework of the Antarctic Treaty, signed in Washington in the middle of the Cold War, 1959. The main purpose of the treaty is to ensure, in the interest of all mankind, that Antarctica shall continue forever to be used exclusively for peaceful purposes and shall not become the scene or object of international discord. The treaty applies south of the 68 degrees south latitude. Antarctica is a continent of some 14 million square kilometers, surrounded by sea. Compared with the surface of the areas of the US, which is 9.6 million square kilometers, or the Russian Federation, which is 17 million square kilometers. This means that Antarctica is about 1.5 times the size of the United States of America. On this Antarctic continent, 90% of the freshwater resources of the globe are frozen. With global warming, some of this ice will start melting. The Arctic is opposite in several ways. The Arctic is a sea, the Arctic Ocean, surrounded by continents. This sea is also some 14 million square kilometers. The overarching legal regime here is the 1982 United Nations Convention to Law of the Sea. This means that the rules of territorial sea, the exclusive economic zone, and the continental shelf apply. The sea ice is melting in the Arctic Ocean. This does not sort of directly affect the sea level, but the albedo effect of the white sea ice that rejects the radiation from the sun disappears, and instead the dark sea surface attracts the radiation, and that is why the heating in the Arctic is twice as fast as in the rest of the globe. But there are also glaciers melting, particularly in Greenland, and I saw when I chaired a major meeting in Ilulissat in 2008, the enormous Ilulissat glacier charging down into the sea in summer. The speed of these kilometers of ice is 50 meters per day. And Greenland melting is plus 7 meters, so you have the sea level. This we will not see. But another effect of the warming is that the permafrost in the whole region is melting, and that releases the gas of methane, a very powerful greenhouse gas. So I make reference to the 2004 Arctic Climate Impact Assessment and the Intergovernmental Panel on Climate Change, the IPCC. Taken together, the effects of climate change, and in particular in the polar regions, will lead to a considerable rise of the global mean sea level in the near future. And I'm afraid that this will generate additional millions of refugees. Just take a look at the world map with an indication of plus 1 meter sea level, which we may have at the turn of the next century, 2100. And without mentioning a particular name, we have one state in the world with 160 million inhabitants, plus 1 meter sea level, 60% of this country will be inhabitable. Where are these people going to go? So this will have very serious consequences also for international peace and security. And it is extremely important that in particular the political leaders of the world realize that they must focus on the long-term effects of these phenomena when they discuss how to maintain international peace and security. And in this context, it is crucial that they also understand the importance of maintaining the rule of law, and of course, the rule of law of which human rights is a core element. And in this analysis, the subject matter that we discuss here in Nuremberg, international criminal law, is a very important content. So I now looked back at the Nuremberg legacy and briefly discussed some aspects of the present geopolitical situation. Let me now address my third part here, main part, the future of international criminal law. The focus of this part will also be on three elements: the law, the performance of the International Criminal Court, and the performance of states. With respect to the law, it is there, the Rome Statute of the International Criminal Court, with its different parts, you know all the chapters of the statute. The other international criminal tribunals are gradually being phased out, and the Rome Statute will be the remaining core criminal law at the international level. This is not to say, as we discussed earlier today, that additional special criminal tribunals may not be established in the future. By example, the Rome Statute does not prevent the UN Security Council from establishing new courts of the same kind as the ICTY and the ICTR. However, this should not be necessary in view of the fact that under Article 13b of the Rome Statute, the Security Council, acting under Chapter 7 of the UN Charter, has the authority to refer situations to the prosecutor in which one or more of the crimes referred to in Article 5 of the statute appears to have been committed. With respect to the development of this international criminal law, I see no major difference from the manner in which criminal law develops at the national level. Basically, it will be through the application of this international law by the different organs and actors under the Rome Statute. The main contribution here will be the case law produced by the ICC. However, there might also be amendments to the Rome Statute. Reference could in this case be made to the so-called Kampala amendments adopted in 2010. With respect to amendments, it is crucial that the integrity of the Rome Statute is maintained. By example, it is very important that attempts by some states to exempt persons at the level of head of state or government from the jurisdiction of the ICC are prevented. This is a very serious threat to the integrity of international criminal law. If the evidence leads the prosecutor to persons at this level, it is precisely such individuals that should be subject to the jurisdiction of the ICC. This is for the simple reason that they normally have immunity under national criminal law. Here, I fully agree with former UN Secretary General Kofi Annan when he was asked about this phenomenon in 2013. He gave a lecture in South Africa. What he said was, quote, "Those leaders who choose to withdraw from the court will earn a badge of shame," unquote. Looking further into the future, in the field of international criminal law, we may also experience additional efforts to administer justice at the international level. This may happen in cases like transitional organized crime, trafficking of persons, terrorism, and corruption. Obviously, a complementary principle would have to be introduced also here if this happens. Let me now address the second element here, the performance of the international criminal law. A key factor for the future of international criminal law will be how the ICC and its organs perform. It is obvious that it takes time before an organ of this complexity functions as intended. The complicating factor here is, of course, that the ICC is critically dependent on cooperation from national authorities. This is not always forthcoming. I do not have the necessary insight in the daily work of the ICC to comment on this in detail, but I will revert to this matter in a moment. With respect to the performance of the organs of the ICC, I have followed this question with particular attention to the manner in which the organs have dealt with the Kenyan cases. You may recall that after the general elections in the presidential elections in Kenya in December 2007, there followed a period of extreme violence in the country. Some 1,300 persons died, and some 650,000 became internally displaced persons. This prompted the African Union to appoint a panel of eminent African personalities to deal with the matter, and they were chaired by former UN Secretary General Kofi Annan. And they were to engage in what became known as the Kenya National Dialogue and Reconciliation. For almost 6 years, I served as a legal advisor to this panel. On a daily basis, we had things to discuss. To make a long story short, a few persons were indicted before the ICC, among them Uhuru Kenyatta and William Ruto. And when I heard that they were on the list of the so-called Camp 6, my heart sank. Uhuru Kenyatta, the son of the first president, and William Ruto, he was a member of the legal committee that I chaired, 4 Kenyans, chaired by me at request of Kofi Annan, that drafted what eventually became the 2008 Kenya Reconciliation Act that governed the coalition government in the country for 5 years. But this was it. They were indicted. In an article in 2014, thoughts regarding these cases as they stood there. Let me quote from my conclusions of the article. In my view, the Kenyan cases before the ICC went wrong from the very beginning, and there is now a serious risk that they might become unmanageable at the trial stage. Needless to say, since I'm not familiar with all the details of the cases, it is difficult to know exactly where the fault lies. But it is obvious that serious mistakes have been committed. The responsibility might rest with the prosecutor, who may have taken the cases to the court before he had made sufficient thorough investigations. The responsibility might also rest with the judges, who obviously have not understood what a court must do if it confirms charges against persons for very serious crime under international law and commits them to trial. Continue, quote, a possible scenario is that the prosecutor approached the court before he had solid cases, and that the judges, Judge Hans-Peter Kahl dissenting, did not realize that they should have sent the cases back to the prosecutor, asking him to make a more reliable investigation before reverting to the court. Now we know that both the cases against Uhuru Kenyatta and William Ruto have been terminated with the ICC. Time does not allow me to go into detail here, but let me express grave concern over how these cases were dealt with by the ICC. I always maintain that the presumption of innocence is a given. As I said in my article just quoted, under no circumstances can anyone be considered guilty of crimes before he or she is found guilty by a competent court of law. However, the question that presents itself here is how the court should deal with persons who are suspected of very grave crimes. One of the first things I was told and I learned as a young court clerk more than 50 years ago is that if somebody is indicted and suspected for very grave crimes, by definition, this person should be arrested and put in detention and remand. Otherwise, he or she may try to evade the trial and also to engage in interfering with the evidence. Today, I ask if this is not precisely what happened in the Kenyan cases. Of course, now I am following the work of the ICC and the Office of the Prosecutor under the guidance of the present prosecutor, Fatou Bensouda, with great interest, and I wish you all the best in your very important work. It is so important. Another concern that I have is that the work of the ICC risks becoming too academic. What I mean by this? Well, academia is necessary, of course, but my experience from the 10 years on the bench in my own country is that justice must be done with precision and pragmatism. Now, the performance of states. As I just said, a complicating factor here is that the ICC is critically dependent on cooperation from national authorities. In my previous presentations on the topic, I pointed to Part 9 of the Rome Statute, and in particular to Article 86, containing a general provision that obligates states to cooperate fully with the ICC in an investigation and prosecution of crimes within the jurisdiction of the court. This provision is followed by a number of detailed rules on the topic, and the question is to what extent states fulfill these requirements. This issue has been discussed by the ICC prosecutors, and I know that they have expressed concern, and other representatives of the court. And it has also been examined in the literature. Let me quote from the conclusions in an article published already before the Rome Statute entered into force. Quote, the ICC will rely heavily on the cooperation of states parties for its success. States parties will be asked to arrest and surrender a suspect, investigate and collect evidence, extend privileges and immunities to ICC officials, protect witnesses, enforce ICC orders for fines and forfeiture, and at times prosecute those who have committed offences against the administration of justice. Key to this cooperation will be domestic legislation permitting the state party to assist the ICC when requested, unquote. As I have said in the past, this means that states have an obligation to carefully examine the national criminal justice system in the process of ratifying the Rome Statute. It is obvious that in many cases it will be necessary to introduce rather elaborate implementation legislation. A natural ingredient in this process could be to see if improvement of a more general nature can be made in the national system based on the Rome Statute. Looking at the specific responsibilities that rest with the states parties for the Rome Statute, other aspects come into the picture. The proper administration of the ICC is heavily dependent on the support of the Assembly of States Parties. In the past, I have expressed concern in relation to three problems, suggesting ways to solve them. First, the question of the qualification of candidates for election to the court, the solution being abolishing List B for ICC judicial candidates. Second, the question of the age, the solution being not to elect judges who will turn 70 years old before the expiration of the 9-year term. And third, the method of electing judges, the solution being appointing an independent committee of experts to review not only the candidates for election, but also the judges who remain on the court, so as to be able to propose candidates who would be most suitable from the point of view of the composition of the ICC as a whole. I'm fully aware that the first suggestion may be problematic. However, I fail to see that it is not possible to find candidates with not only courtroom experience, which in my view is an absolute prerequisite to sit on an international court at this level, and also find candidates who have academic expertise. I think that would be. And comes time, candidate list B will be more and more problematic in light of the fact that there will be candidates who have served in different functions in the ICC who will be much more competent than most candidates at the national level. With respect to the third suggestion, I was very pleased when the Assembly of State Parties decided to appoint the Advisory Committee on Nominations of Judges. And with respect to the second suggestion, I found that it was a step in the right direction when this Advisory Committee included date of birth in the suggested arrangement for the CV of candidates. Of course, a true judge would understand that to present oneself as a candidate for the court without disclosing one's date of birth is unethical. A particular problem is that many states, including some of the most powerful ones, are not parties to the Rome Statute. Among them, the permanent members of the Security Council, China, the Russian Federation, and the United States of America. This is one of the major challenges to the future of international criminal law. It also brings to the forefront the role of the Security Council. This issue I've also addressed in the past, pointing to the contribution that the members of the Security Council could make to our efforts to establish the rule of law, both at national and international levels, and the need for crime prevention and protection of human rights. Against this background, it is of tremendous importance that the Security Council applies Article 13b with consequence, using the same yardstick in the world. In addition, the Council should follow suit and act in accordance with its own resolutions. It goes without saying that applying this provision in the Rome Statute and then not follow suit in support of the court orders is unacceptable. I also reiterate that the funding of the ICC of these cases should be provided by the United Nations. Finally, in this context, I would like to mention a project called Law and Diplomacy. It is a multi-year project conducted by the International Bar Association and Académie Diplomatique Internationale. The Academy is an international organization dedicated to promoting modern diplomacy and contributing to understanding the analysis of the emerging dynamics in global affairs. The project is intended to identify principles and guidelines for avoiding contradictions between diplomatic and judicial processes, as well as potential for cooperation in responding to international crises that involve potential violations of international humanitarian and criminal law. The project will, in the near future, publish 5 case studies in which conclusions are drawn based upon the experiences of the operations in Bosnia, Darfur, Kosovo, Libya, and Rwanda. Hopefully, this will be of assistance in the future, in particular to the United Nations. To conclude, the future of international criminal law is a very important matter, closely linked to the development in all sectors of our global village. In the past, I've asked the question if it would be possible to administer a country if the criminal law all of a sudden did not, or the criminal justice system all of a sudden did not apply in certain municipalities or counties. Obviously not. I therefore reiterate with great emphasis that the globalization means that international criminal law must apply and an international criminal justice system must function all around the world. This is a goal of, shall we say, paramount importance for the future. And international prosecutors, you present here, have a very important role to fulfill here. Based on your unique and special competence and experience, you can assist in explaining this to those who make decisions with respect to these matters at the political level. And finally, my criteria, empowerment is a precondition for international peace and security, and in addition, for justice. Thank you for your attention, and thank you for bearing with me. We started 20 minutes late, and I had 3/4 to my disposal, but I tried to do it in a little less time, and this is why I was maybe a bit hasty here and there. But thank you for attention.